Presents a significant test of Ireland's gender recognition framework nearly a decade after the groundbreaking Gender Recognition Act 2015 established self-identification for transgender adults. The outcome could redefine how the legal system acknowledges parenthood for transgender people and set precedents affecting everything from citizenship transmission to birth certification for years to come. Case background: the family at the heart of the legal challenge. The claimant, who cannot be identified by court order, is an Irish citizen residing in the UK with her wife and their child. The child's mother is not an Irish citizen, making citizenship eligibility dependent on the claimant's status as a parent. The sequence of events that led to the current legal challenge is significant. The claimant, who was assigned male at birth, had stored frozen sperm with a UK fertility clinic prior to her gender transition. She subsequently changed her name, transitioned from male to female under UK law, and obtained a UK gender recognition certificate. Ireland recognizes this gender recognition under its own Gender Recognition Act 2015, which allows transgender people to change their legal gender through self-declaration without medical requirements or assessment. The woman married her female partner and used the previously stored frozen sperm for an IVF procedure that resulted in the birth of their child. When the family applied to have the child registered on Ireland's Foreign Births Register, which would grant the child Irish citizenship through the claimant's lineage, the Department of Foreign Affairs refused the application. The department's position was that, under Irish law, as applied to date, the mother of the child is the woman who gives birth to the child, and therefore the child would derive their citizenship through that mother. The legal conflict: arguments from both sides. The plaintiff's position: the child, represented by the trans woman as their next friend, is seeking several remedies from the High Court: a declaration that she is legally and genetically a parent of the child, an order compelling the state to register the child on the Foreign Births Register, an order for the child to be granted citizenship under Section 7(1) of the Irish Nationality and Citizenship Act 1956. The claimant contends that being forced to identify as the father of the child would constitute an offensive, discriminatory, and unjust attack on her person, gender identity, and legal status. She further argues that this would invalidate me as a trans woman, invalidate my legal status as a woman, and invalidate my same-sex marriage. Notably, the claimant acknowledges that she could have possibly obtained citizenship for the child by claiming to be the father, but argues this would require her to misrepresent her identity and compromise the validity of her same-sex marriage. The state's position and current legal framework. The state's refusal appears based on Ireland's current legal framework for parentage, which recognizes the birth mother as the child's mother in all circumstances. This position reflects the tension between Ireland's progressive gender recognition laws and its more traditional approach to establishing legal parenthood. Ireland's Gender Recognition Act 2015 was groundbreaking when introduced, making Ireland the fourth country worldwide to allow legal gender change through self-declaration. The legislation enables adults to change their legal gender without medical intervention or assessment. However, the Act specifically states that legal recognition of a person's new gender is not retrospective, meaning that any rights, responsibilities, and consequences of actions by you before the date of recognition remain unaffected. The state's position suggests that recognizing the claimant as a mother would require retroactive application of her gender recognition to the time before her transition when her sperm was collected.